All right. So welcome everyone to this presentation from Housing Court Answers. This presentation is about overcharge in rent stabilized apartments, a fascinating topic. And to present on this fascinating topic, we have two lawyers from Himmelstein, Gribben and Joseph, LLP. Um, let's see. First, Serge Joseph, would you like to say hi to everyone, introduce yourself?
Sure. Good afternoon, everyone. My name is Serge Joseph, and I'm one of the partners in the firm. The outline does misidentify the firm. It says Hemmelstein, McConnell, Gribben, and Joseph LLP, but we, in fact, recently changed the name. We dropped the McConnell, so we are now only Hemmelstein, Gribben, and Joseph. And with me, I have one of the other attorneys who's going to be observing, and she may jump in and answer questions or correct me if I get something wrong. She's Vanessa Vecchiarello. I'm pretty sure I'm still not pronouncing her name properly, but that's my introduction.
Close enough, close enough.
So, Sarah, should I jump ahead and just get going?
Please do so. And just a reminder to everyone, I'm sure you'll have questions as we go through this presentation. Please put your questions into the chat and we'll try to get to a good number of them while we're on the document being discussed. And anything that we don't get to in that moment, we'll try to get to it at the end of the presentation. So please take advantage of the chat for asking your questions.
Oh, good. Well, thank you very much, Sarah, and thank you for putting this together. Just sort of a brief description of the documents that we have uploaded, if you will. So there is an outline. I doubt very much that we are going to be able to go through each of the topic and discussed in the outline. I would love to get to a couple of things including sort of, the mechanics of a rent overcharge, how to file one, how to look at the necessary DHCR documents to determine whether or not there is an overcharge. So that's what I'll discuss the history, I'll discuss the law a bit, but what I would really like to focus on, given that most of you want sort of the hands-on knowledge and hands-on, specifics. I'll discuss. Would or prefer to spend some time discussing that. So, in terms of the documents, we have the first document. Obviously, is the outline itself. I'm not sure in what order the other documents are in, but there should be rent overcharge application. So that's going to be the actual application if you decide to file a rent overcharge complaint with DHCR. And we'll get to a discussion about where to file overcharge. There should also be a sample DHCR registration apartment history. I I white out the apartment number just for privacy reasons. But if an apartment is subject to rent stabilization, the landlord should have registered the apartment rent with DHCR, and you could access the apartment rent registration history at DHCR. So I would love, if possible, to spend some time going over what a rent registration history look like, what it says, why it's important, and so forth. Now, very briefly, there are two more documents. One is a DHCR fact sheet number 36. It's a historical deregulation of rent and income threshold. Again, we'll discuss it, but this is a very good sheet to have not far, or at least a place where you could, access and make reference to it, because it tells you what the threshold for deregulations have been over the years. So you want to know, for instance, that from 1997 to 2011, the threshold was $2,000, and it has changed over the years. So we'll, hopefully discuss that. Last but not least is tenant advocate and tenants lawyers, I don't want to say Bible because our Bible is actually the 10 book, but this is this one, which is the guideline board chart of all the orders from order number 1 to order number 55. So it has the chart, it has what the RGB rent guideline board increase percentages have been. And if you're gonna do a rent overcharge complaint, or if you want to determine whether or not your rent is correct, you will need this chart because this is what you use to plug in what the increases should have been from, I think it's from 1984 forward. So you know what? From 1970 forward. So it goes back even further. All right, so those are the documents that hopefully we'll get to. So why don't we start? So am I good, Sarah? Should I keep going?
Yeah, so do you want to just we're right now just on the overview page.
Correct, correct.
Let me know where you want to go after that.
Yeah, so that's I think an overview is a great. I'm not a history buff or a history professor, so I'm not gonna give you dates and whatnot. But what I do want to touch on is like why does rent regulation exist? And I think anyone having a discussion about rent regulation and about why there are rent regulatory laws, needs to start with the very basic understanding of the relationship between tenants and landlords. And that relationship, in essence, is defined by incredible imbalances in power. Obviously, every once in a while you'll have a very rich tenant and a very poor landlord, but that's a rare occasion. More often than not, it's just the opposite. You have um, an imbalance in financial and economic power, but you also have other imbalances. Not just that the landlords tend to be richer, deeper pocketed, but you have also imbalances as to information about the apartment. Landlords have more information about their apartment than a tenant walking into the relationship. The landlord knows whether or not the apartment is, habitable for human habitation or not. The landlord knows about the history of lead paint and the history of bed bugs, whereas a tenant walking into a landlord-tenant relationship tends to be someone coming, out of the street and without knowledge, without information about the apartment or about the building. So that's one imbalance, the imbalance of information. The other imbalance, I think, which is important to keep in mind is, for a landlord mostly renting and collecting rent, the value is a financial one, It's an economic one. Whereas for a tenant, particularly a tenant who intends to put roots in the apartment and consider the apartment a home, there's all sort of emotional ties. Suddenly an apartment becomes a home. And there are also social and communal ties. A tenant's going to register, enroll their children to the local school. They're going to make friends. They're going to have relationship with the local stores. So that creates, an emotional attachment which doesn't exist for a landlord who may see and renting an apartment simply as a means to collect a paycheck. So in light of this incredible imbalance, the state, initially the federal government, right, around World War II, intervened and enacted rent control laws to sort of, help with this imbalance. Later, after the federal government withdrew from local rent regulatory scheme, the state intervened and enacted rent control. I think from 1947, and much later on in 1969, the city enacted, initially rent stabilization, and then in 1974, I'm not going to go into all the, machinations that resulted in these different laws, but then in 1974, the state actually enacted the ETPA, the Emergency Tenant Protection Act of 1974. So that's basically the background. And there were some changes to rent regulation. Initially, there was vacancy decontrol, and then there was luxury high income, high rent decontrol. And then a great thing happened in 2019. The state enacted what we now call the HSTPA, which stands for the Housing Stability Tenant Protection Act of 2019. It became effective in June of 2019, and it did a couple of things, and we're gonna, talk about those things. But the thing that you need to remember is it made away with vacancy decontrol. So what's vacancy decontrol? Because this is going to come up quite a bit. So vacancy decontrol was if an apartment reached the threshold, you may recall me talking about the different levels of threshold. Beyond a certain level, if an apartment became vacant and the rent was at or above the threshold, then the apartment could be deregulated completely, could be taken out of rent stabilization. So what the HSTPA did was done away with vacancy decontrol, but it didn't recapture those apartments that were previously deregulated. It simply said going forward, apartments, where their rents reach the certain threshold could no longer be deregulated upon vacancy. Alrighty, so that's basically my very brief history and brief overview of rent regulatory status and legal rent. So I think that the second topic that I see in my outline is choice of forum and practical considerations. All right. So choice of forum. So you have basically three forums, three places where you can litigate or adjudicate or have determined your rent regulatory status. That's number one, because obviously you can't file a rent overcharge if the apartment is not rent regulated. So the first thing you need before you can get to whether the landlord is overcharging you, whether the landlord is charging you the legal, proper, regulated rent, is to have a determination that your apartment is subject to rent stabilization. So what are the three different forums that you can adjudicate or litigate or decide the issue of your rent regulatory status and legal rent? Number one is DHCR. DHCR stands for Division Housing Community and Renewal. It is the state agency that since 1984 has administered rent regulation, actually, rent control and rent stabilization. We're going to focus our attention mostly on rent stabilization, but there is another scheme, another regulatory scheme of rent regulation, and that's rent control. But we won't talk about that. We're just going to focus our attention on rent stabilization. So you can adjudicate your rent status and your rent overcharge at DHCR. Oh wow, this is perfect. Vanessa is answering question as I talk. This is like, a tag team for you. You get so that's perfect. So because I kept seeing a bunch of questions and I'm like, gee, I wonder if I'm going to get to it. So this is good that Vanessa is answering it as we get along.
Yeah, and
It,
I put a message into the chat for everyone, but if you could try to keep the question on the topic that Serge is presenting on right now, that would help. And then I can interject and ask him the question. And so any of the ones that were not, I said there were a lot of questions because so many people come into this with a specific issue. Anything that we don't get into on the specific moment, we'll just try to address it at the end of the presentation.
oh,
Okay.
perfect. Thank you.
Okay.
All right. So choice of forum. So the first is the administrative agency, DHCR. The DHCR has, and we'll talk about that because one of the forms you'll recall is the rent overcharge complaint form. But you can you can adjudicate your rent regulatory status and rent overcharge um, claim at DHCR. All right, so that's one. The second place you could adjudicate is in housing court. Um, Unfortunately, there isn't um, a a type of case that tenants can bring in housing court to affirmatively litigate um, rent rent status and rent overcharge. They can only do so defensively. They can only do so if their landlord sues them for non-payment of rent or sues them for, to evict them in a kind of case that's called a holdover case. Then once the tenant is in court defending against the non-payment rent, the non-payment of rent case or the holdover case, then they can bring as a affirmative defense or as a counterclaim their rent stabilization regulatory status or overcharge claims. Okay, so unfortunately, in landlord tenant or housing court, tenant can adjudicate their claim only defensively. There is a type of case where tenants can affirmatively bring cases, such as an HP case or a harassment case, but those cases are specific to an HP case, which stands for housing part case, are specific to repair. So if a tenant has a repair issue, they can bring an HP case in housing court to force the landlord to do the work. So if a tenant is being harassed, they can bring in an HP case to, compel the landlord to stop the harassment, but not to litigate the rent regulatory scheme. The last forum that a tenant can, potentially litigate a claim is in Supreme Court. Supreme Court is a state court, unlike housing court, which is a city court, a local court. Um, Supreme Court is a state court, and it has power or jurisdiction over everything. Well, not, but over a broad array of subject matters, including overcharges and including most DHCR claims. There are certain claims that can only be bought in at DHCR, such as if an apartment leaves rent control and goes into rent stabilization, the tenant can challenge the initial rent by doing what's called a fair market rent appeal. And that fair market rent appeal can only be adjudicated at DHCR. DHCR has the exclusive jurisdiction for that. But otherwise, most claims can be litigated in Supreme Court. All right. So,
Oh, so we have a question going back to housing court. You had mentioned how overcharge can be a defense that's used in a case where the landlord is suing the tenant in a non-payment or holdover case. Both are technically eviction cases. And somebody in the chat asked that they heard that overcharge is only a defense in non-payment cases, but not in holdover cases. Could you speak to that?
Oh, good. So let's be specific, right? Because, we are lawyers, we're not philosophers. So let's say a landlord sues a tenant for termination of lease. So they say, hey, lease is over, I'm evicting you. They do their usual 90-day notice or whatever, and then they do their good cause eviction thing. They say, we don't qualify because XYZ. As a defense to a holdover based on termination of lease, the tenant can say, I'm rent stabilized. Therefore, I'm protected under rent stabilization, and the landlord failed to renew my lease. And then in all holdover cases, landlords, if you look at the wherefore clause, the last clause where the landlord says, wherefore I asked for the tenant's eviction, I asked for legal fees, they also ask for use and occupancy. Or in other words, they ask for rent. Oftentimes they'll say, even in a holdover where they're just trying to evict a tenant, they'll say, we also want the rent, because the last time the tenant paid rent was, after the tenant received the termination notice. So in that instance, when the landlord is seeking use and occupancy or rent after the expiration of the lease, the tenant can say, well, wait a minute, the rent that I was paying all along was an overcharge because I'm subject to rent stabilization. So there are a number of instances where even in a holdover, a tenant can raise as an affirmative defense or as a counterclaim their status as rent regulated, and the fact that, or they may even, in an overcharge, have a counterclaim for, I'm sorry, in a holdover proceeding, they can have a counterclaim for rent overcharge. They could be like, oh, I've been there for 4 years and the landlord has been overcharging me, and the landlord tenant judge, even in the holdover case, should award me overcharge and treble damages. So that happens quite often.
Right. And sometimes housing court answers, sometimes we find even rent stabilized tenants will sometimes have a holdover case begun against them because the landlord says, you didn't sign your renewal lease as you are obligated to do as part of being a rent stabilized tenant. And then sometimes the tenant says, well, the reason I didn't sign the renewal lease was because I think that the rent was wrong.
Correct,
Because
correct. Yeah.
that
Mhm.
could be another situation. I mean, there's so many different situations that could lead to a holdover case, and it's really going, you know, it it'll depend on the exact story of what's been going on. But
Absolutely, absolutely. So we lawyers deal, again, we're not philosophers. We're in the business of handling a specific case with specific facts where specific laws apply. So, but you are right, Sarah. That's another example where even in a holdover case, the tenant could raise an affirmative defense of the rent is wrong, and that's why I didn't sign my lease, or the landlord try to sneak in additional adverse provision in the lease, and that's why I rejected it. That's why I didn't sign it in. So yeah, so absolutely. All right. So were there any other question regarding the specific form?
uh, let me. Oh, so if a tenant mentions overcharge at the time of lease renewal and asks for an explanation but doesn't get one, can believing that the rent on the lease is an overcharge due to receiving the rent history be a defense in a holdover? Oh, they think that
Yeah,
was
was
so
that?
that question was answered by
Yeah.
yeah.
So, all right. So those are the three choices to, forum. We call where you litigate your case forum, and then the practical consideration. So let's talk very briefly about that, and we'll try to do it very very fast. Obviously, money, is a practical consideration. DHCR, the form we'll go through the form, but it's pretty self-explanatory, and they do try to make things user-friendly. But on the other hand, DHCR takes a long time to make a decision. So it's cheaper to go to DHCR to litigate your rent stabilization issue, but it'll also take a longer time uh, compared to the others to get a response. The other issue with DHCR is DHCR tends to be sort of cryptic, and not very transparent. So whereas if you go to court, you'll have a judge sitting usually, up on high, and you'll have the landlord and you'll have the tenant, um, you know, facing the judge, and they'll present their argument, and you'll be able to address the argument, or they'll serve you papers, and you'll get the papers right away. The DHCR, that kind of interaction um, doesn't happen. What happened is you mail your papers to DHCR, and then you won't hear anything for months. Then you'll get a copy of the landlord's response. I mean, and it could be years, and the DHCR cover letter will say, "Oh, you have 2 weeks to respond to it," and then you'll respond to it, and then you won't hear anything, and then so forth. The process can go on, for quite a bit of time, infinitum. So that's the HCR. And the other consideration with the HCR too is you don't really get discovery. You don't really get, so if the landlord submit something, if the landlord says, oh, my brother-in-law, well, the landlord won't say my brother-in-law did the work, but the landlord will say such and such company did the work, and you won't know whether or not such and such company is, the landlord's brother-in-law, unless you do your own, private investigation. Um, and you won't be able to, um, you know, cross-examine the landlord as to the veracity and truthfulness of the landlord's submission. So most things are done on paper. So that's the HCR. So that's you have to, when you consider where to file your your claim, you have to take into account the lack of, I call it the lack of transparency, and I call it, the evidentiary impediment that you would face at DHCR. And the other thing that, and I don't know how true that is, but there used to be, particularly when DHCR was under Pataki. Pataki was for you youngsters, Pataki was a governor in New York before, I don't know, 3, 4 governors ago, and he was Republican, and he um and I don't know, I guess he installed a lot of conservative um bureaucrats. I'm trying to be diplomatic. Bureaucrats in there. Pointy-headed bureaucrats at the DHCR, and so the DHCR had a reputation for being, somewhat conservative. How's that? Is that proper? So somewhat conservative,
That
pro
works.
landlord. All right. So you have to consider that. So for adjudicating or litigating your claim in Supreme Court is obviously expensive. Supreme Court is not really a forum, a place where tenants without an attorney can maneuver and navigate the different rules and procedures and, e-filing and so forth. So, it's expensive to hire an attorney. It's expensive to um, buy an index number. It's expensive to do RJI. So the Supreme Court is definitely expensive, much more expensive. Um, and the last forum is defensive housing court. And, there are some positive, obviously, if you're going to be sued anyway and you have a claim, obviously you will assert your claim, both as a defense and as an overcharge. But if you don't have a claim, the issue is going to be, well, do you withhold your rent and force the landlord to sue you, given all the other negative adverse impact that having a lawsuit can have on, your credit history and your ability to rent, in the future or buy in the future. So you have to consider that. Although there used to be a tenant list that's, was supposedly done away with, but my guess is landlords still have a way of accessing who's been sued and who hasn't. So
Right.
so those are the considerations that you have to.
Housing court answers, we do get calls from tenants because they end up on tenant screening reports, and the tenant blacklist, even though technically in 2019 it is supposed to be illegal, it is also true that landlords are taking advantage of, they have access to tenant screening reports. There are people who go to the housing courts and we see them at the computers collecting information about court dates. So yeah, it's just something that we try to let tenants know about. I mean, sometimes when you're in housing court, sometimes you just have no choice because just life got you there.
Yeah.
So it's something we try to give people information about, but yeah, it's frustrating. And technically, if a landlord denies you, like turns you down for an apartment and says, "Oh, it's because I found you on the tenant blacklist," you should be able to say, "Aha, that's discrimination," and you're not supposed to be able to do that. But it's hard when they don't tell you why they turned down your application for an apartment.
All right, so those are the choices you have available to litigate your claim and the practical consideration. So why don't we move into like some substantive stuff? Um, how do you, again, I mentioned before that, your rent overcharge claim is grounded upon your status. If you're not, folks call me like, "Oh, I think my landlord's been overcharging me." And I'm like, "Well, are you rent stabilized?" "No, I'm not rent stabilized." I'm like, "Well, there's nothing I can do for you." If you're not rent regulated, then the landlord and you can enter into whatever agreement and rent, with some exceptions, you want. So the first issue is to determine whether or not your apartment's subject to rent regulation. Generally speaking, rent regulation applies to generally, and I know folks are going to be like, "Oh, there's a bunch of exceptions." There are exceptions to everything, but we're talking about generalities. Generally speaking, rent regulation applies to apartments constructed and occupied prior to January 1, 1974. Of course, there are many apartments that are post 1974 that are rent regulated because they got J51. They were built pursuant to 421A. They were previously office buildings and converted via 421G. But generally speaking, and then 421 has like, believe it or not, Sarah and Vanessa. 421 has all kind of letters from A to
And now there's 485 something, the
yeah,
brand new subsidy for developing new buildings. But maybe for the folks in the audience, if you got an apartment through a New York City Housing Connect lottery, no, most of the time that should be a rent stabilized apartment unless there's some other program that it was part of. But most of those new apartments should be rent stabilized. And so you're dealing with these rent stabilization rules that a lot of the older apartments have been working with for a long time.
yeah, that's true. So, um, yeah, for in return for receipt of tax break and tax benefits and tax, abatement, sometimes, you know, adding up to billions and zillions of dollars. Landlords are supposed to agree in these new buildings to, set aside a, a certain percentage of apartments for low income, medium income, and you're right. Most of these apartments should be subject to rent, should be subject to rent. Um, just as an aside, um, we litigated and went all the way up to the Court of Appeals, um, buildings in Lower Manhattan, like south of Canal Street. And most of them were previously office buildings. And then, when I guess it was in the middle 1990s, the Wall Street area, the buildings were no longer equipped for computer and whatnot. So, and a lot of these office buildings were under occupied. Nobody wanted to rent them as office buildings. So they were just sitting there empty. The government came in and offered, you know, substantial benefits to convert these buildings into residential apartments. And they did so pursuant to the 421G regulation. And these apartments were supposed to be subject to rent stabilization. Of course, what landlords tend to do with, it is in their character, in their very DNA. They got the benefits and they said, forget rent stabilization. So a couple of, tenants got together, we sued, and we got them rent regulation. Um, so keep that in mind. So I think Sarah is right. Many of these new um, new construction can be rent regulated. And guess what? Nobody's gonna tell you. DHCR ain't gonna tell you. Your landlord certainly is not gonna tell you. And again, remember when we first started talking about the imbalance that exists, not only in power and economic power and emotional attachment, but also in information. The landlord knows the benefits they agreed to, and they know what the quid pro quo was, but they probably won't tell you. Same thing with like these apartments will, you know, the first rent. Well, what should the first rent be? What should the first rent in a 421G, no, 421A, forgive me, 421A apartment be? Well, there are regulation. HPD has a bunch of regulations set up in order to determine that per room count, rent, and whatnot. But tenants are not going to know that. And most tenants won't even challenge it because they simply lack the information. But anyway, I digress.
Yeah.
So,
We did have a couple questions in the chat. It's still related to the venue choosing issue.
sure, yeah, that's great. Love venue.
Yeah. So a question, some questions have come up about the amount of time that it takes DHCR to make a decision when you file a question in there. And Vanessa has been answering questions in the chat, but maybe what would be an overall, do you have an overall sense of how long it usually takes DHCR to make a decision when you choose DHCR as your path?
Well, um, I I want to say years, and I'm not being a smart guy, smart Alec. I'm not being a wise guy. I'm not being a wise guy when I say sometimes it even takes decades, but it takes years. It takes. I have not had a DHCR claim that has been decided in less than 4 years.
Right. And
So I actually, sorry, Serge, can I just jump in to
no,
say,
please.
I actually did have a client when I was in legal services whose overcharge and improper destabilization claims were decided pretty quickly, and we were not expecting it to be that quick. And it was, I would say, maybe a year or year and a half that she had to wait before it was decided. And the reason I just want to flag that is because she wound up in a tough situation because DHCR sent the notices and she didn't receive them or she missed them. And the DHCR imposes timelines in which a tenant has to respond. So it's definitely something that a tenant has to sort of, be patient because it can last, as they're just saying, years, even a decade or more. But you also have to be mindful of when you get those notices, responding to them.
Yeah, thank you. And it can be tough if your landlord is also the type that doesn't keep your mailbox in good working order. And there was another comment from an attendee who said that it seems like DHCR accepts any scanty evidence of improvements from the landlord, and it's hard for tenants to fight. You had talked about, I mean, I guess maybe it's a reminder to everyone that for a very long time with IAIs, prior to the rules around improvements, um, it's not like a landlord had to file a whole bunch of papers with DHCR to get approval to do basically they took the landlord's word for it. And then it was only if the tenant complained about something that anybody would be asking to see receipts, etc. Um, so I was wondering if you could speak to, um, how like you mentioned evidentiary issues with DHCR versus housing court versus Supreme Court. If you could speak to
Sure,
the evidence process with DHCR versus housing court, maybe.
sure. Vanessa, did you want to take a stab at it?
Sure.
Okay.
So yes, that's absolutely what you're saying is 100% true, Sarah. With MCI's major capital improvements, the landlord has to go through the DHCR and get pre-approval for those. But that's not the case with IAI's individual apartment improvements, which can be used as a basis to take, additional increases on the rent. Um, and if you file an overcharge claim with the DHCR, the landlord will then have to produce documentation that those IAIs took place to justify any increases over the rent guidelines board allowable increases for each year. Um, so there is some burden for the landlord to be able to produce documentation. I hear what you're saying about like the level of scrutiny with the DHCR, and that's one of the things that, when we're advising clients, we tell them to consider in terms of choosing their forum. With the DHCR, as Serge was saying, you submit a bunch of documents, the landlord submits a bunch of documents, the DHCR reviews them and sort of makes a determination on those grounds. In housing court, you have a little bit more ability to challenge some of the stuff that the owner puts forward. You can cross-examine the landlord or his agents. You can, sort of challenge the veracity of his documentation that he's putting forth. So that's just sort of one of the, benefits sometimes to a tenant of being in housing court if you're challenging the rent and overcharge on the basis of IAIs.
Yeah. Yeah, I mean, I think this is a nice segue to the next topic that we're going to discuss, which is high rent vacancy, and then right after that is allowable rent increases, where we talk about calculating IAIs. So, um, so you're an apartment, your rent is, sometimes it's not even above the threshold. Your rent is near the threshold. It's $2,500. The threshold right before the HSCPA, right before 2019, when the state enacted the HSCPA and done away with vacancy deregulation, the threshold was $2,774.76. So conceivably, you in your apartment, you see that, you're paying 2,500. So you saying, hey, wait a minute, my rent is not above the threshold, and your landlord is saying, well, it may not be above the threshold now, but at one time, you know, since 1993, since 1993, your rent had reached that threshold. And once it reached that threshold and became vacant, your landlord claims we the landlord were legally allowed and in fact deregulated your apartment. So I mean, so that's gonna be. I mean, if you live in an apartment and you don't know your status, or if your landlord is saying you have been deregulated, that's the first thing you're gonna have to do. The first thing you're gonna have to do is determine whether at one time or another the apartment exceeded the threshold and was deregulated. So, and the in our outline, we provide what the threshold what the threshold limits were. And very briefly, from 93 to 2011, it was $2,000. And then 2000, 2011, it jumped to 2,500. And then in 2015, it jumped to 2,700. So you could see, I mean, if in 1994, the apartment had a legal rent of $2,000, that it could be deregulated. So you want to make sure that you know what the threshold limits are, and you want to see and looking at, and we'll talk about how to look at the DHCR rent history and see whether or not the legal regulated registered rent exceeded that threshold. Okay, so you wanna make sure to keep in mind the threshold, and you want to make sure that when you're looking at the DHCR rent history, you that you are able to explain the rent increases and determine whether the legal rent exceeded the threshold. The next most common way a landlord is able to deregulate apartment is what Sarah and Vanessa were just talking about, which is IAI, individual apartment rent increases. Okay. Now again, I'm going to come back this theme of um, of imbalance in power, and in this instance, it's imbalance in information. You don't know how many times a potential client will come to us and they'll have the DHCR rent history. We will do the calculation, and and there'll be a little gap, and and they'll be like, well, do I have an overcharge? And our response will be, maybe you do, maybe you don't. I don't know what the landlord is gonna say. I don't know whether or not the landlord is gonna say they did apartment improvement. So our next question is like, well, does your bathroom look as if it's been recently renovated? Does your kitchen look as if how much do you think those renovations, if it does look recently renovated, how much do you think it costs? And to be frank with you, we will never know. We'll just never know. It's like, you know, um, and at DHCR, if you're litigating your case at DHCR, you're relying simply on documents the landlord submit. And if it's in Supreme Court and Housing Court, maybe you'll get discovery, maybe you'll get to have what's called a deposition of the person, the contractor who did the work, and you'll be able to, examine them and see if you could poke hole. But there is that gap in information and knowledge. Okay,
Yeah.
so just keep that in mind. So
One thing that I sometimes tell people, because we get questions about rent histories all the time, and so much is so unknowable. Like, what did it cost it? Like, did the cabinets look like they were renovated in 1995 or 2005? Like, and you have to think, well, what was the style of it? But one thing that I sometimes tell people to look for is, well, if the alleged renovation happened in, I don't know, 2015, but then you open all of your appliances and they all say that they were manufactured in 1995, it might be a sign that that renovation in 2015 might be poke holeable. I don't think that's the right adjective, but at least with appliances, they have years, so it's at least something you could start your own research into.
oh, absolutely. I mean, we have people, we have experts who can, come and say, oh, I recognize this. This is this, and they'll look at the model number, and they'll be able to say, oh, and comparing the wear and tear, we think it's this. So, but again, though, I mean, I mean, the courts will give weight to both sides and try to determine. DHCR, if the landlord has a cash check, and you can't show that the contractor and the landlord are somewhat, in cahoots or are related entities is the proper legal term. Um, sometimes it's obvious, right? Sometimes they have the same address, and sometimes the officer's name would be the same, and you're like really. But more often than not, it's a little bit more difficult to show that the renovations are, you know um, if not, bogus, but exaggerated. Or so sometimes, the receipt won't identify the apartment number. Every once in a while, landlord will be stupid enough to use the same receipt for different apartments. And then, we're like, they know we represented different tenants in the building. Do they think we weren't gonna pull our old file to see what receipt they submitted? But but the point though is to keep in mind that there is that imbalance in information and knowledge. They have it, we don't. We're trying to decipher, their machination and their attempt to cloud and hide things.
Well, I
Um,
guess that's another reason why it's valuable for tenants in the same building to be talking to each other, because maybe this tenant got discovery related to their apartment and then could share with others who say, oh, I think
Absolutely.
we saw this, Yeah.
Yeah, very much so. So we discuss the IAI laws have changed quite a bit. So in the past, it used to be, um, the landlord was entitled to recoup 1/40th of their total investment. I would give an example, but I'm not. So if they spend $400, I'll take a shot anyway. If they spend $400, then the landlord could increase the rent by $10. I think that's what 1/40th is. If
I
the
think you're right.
Yeah, if the building had 35 or fewer, and then if the building had more than 35, then the landlord was entitled to 1/60th. But in 2000, after the HSCPA, oh, and then okay, one other thing, and the increase would be permanent. The increase would be permanent. So prior to 2019, whatever IAI the landlord was able to secure, the 1/40th or the 1/60th, that would become a permanent part of the rent. So it would be, that $40, no, that $10. Well, I don't remember. Whatever the increase was, but that became part of the rent forever. But after 2019, with the HSCPA, um, the the increase became temporary. But this is our politicians at work. They're like, we secured tenants' right, we made IAI temporary, but things out 30 years. 30 years, most of us would have moved on, but
Oh, God, maybe
temporary is
died.
temporary is 30 years. So and then it changed, it changed quite a bit. It went to 1/66 if the apartment had 35, I'm sorry, 1/166 if the apartment had 35 or less. And then and then 1/180th if the apartment had 35 or more. And then it was capped at 30,000. So irrespective of how much money, landlord spend $1 million in IAI, the most the landlord would be able to get is $30,000. And then the temporary period was reduced to 15-year period, and not quote unquote 30-year temporary period. Um, All right. So the next, and I see that I've been talking for about an hour or so, and I haven't even gotten to vacancy allowance, but I really do want to look at the DHCR form. So I'm gonna jump after talking about the vacancy allowance, I'm going to jump to rent registration and um, looking at the rent registration, and then how to calculate an overcharge, and then I guess I'll open it to question. Vacancy allowance, vacancy allowance. To be completely honest with you, that's something that I don't have like fully grasped. I guess potentially because I haven't done it enough. But there is a cheat sheet which you have, and I won't talk much about it. But the the gist of it is the landlord was allowed to jump the rent to like 20% if a tenant um prior to the HSCPA, if a tenant vacated, and they were also able to get what was called a longevity increase. Um, so I would encourage you when you are doing rent calculation to look at the vacancy allowance and to look at the longevity increase, which we discussed. Okay.
Yeah, a lot of
Longevity.
advocates and activists used to call this before the vacancy allowance went away in 2019. A lot of us used to call it the eviction bonus.
Yeah.
If you can make a person miserable enough in their apartment, they'll move out, or maybe you evict them, and then boom, you get 20%, whether you don't even have to fix up the apartment in between tenants, and you could get that 20% bonus. And it's nice that it went away after HSTPA.
Well, you get vacancy 20% plus you get longevity. So if they had a long-term tenants in there for 20 years and they kept fighting and they didn't do any repairs and suddenly they got them out, well, they would be able to automatically increase the rent by 20%. And then they could get a longevity increase, which is 0.06 times 20%, which can add up pretty quick. And before vacancy decontrol was done away with, you could see how like those little increases could very quickly get the rent above the threshold that we talked about. So keep that in mind when you are looking at a rent overcharge complaint and the um, DHCR um, rent history. The next topic I had was evidentiary issues, which I didn't even put anything in because I thought, we probably would talk about it as we have been. Um, and all right, after that, we have statute of limitations. Okay, now, statute of limitation. Um, so statute of limitation is kind of strange because there are two, when we think of statute of limitations and in every other context, we tend to think of it in terms of kind of if you don't bring your case by this date certain, even if you had a strong case, you lose your case. You will be precluded from even bringing the case. So let's say, you were in a car accident. I don't even know what the statute of limitation is on a car accident, but let's say it's 3 years, which I think is um, personal injury, negligence. Your car accident, you're walking down the street and some person jumped the red light and hit you. So typically we think of statute of limitation like, look, you have 3 years from the date you were hit by the car. Um, if you bring your case prior to the 3 years, then you have a case. You litigate it. If you don't bring the case prior to three, if you bring it 3 years in one day, that case goes away. You lose. Uh, but rent stabilization is a little different, right? Because there are two aspects to rent stabilization. One is there's a look back period to determine how to calculate rent. And then the other one is there's the recoverable period. Because I mean, if you're still in a and I think it's an issue because most people tend to remain in their apartment. Obviously, if you move out your apartment and then right now it's 6 years, and then 6 years, 6 years and 1 day later you bring an overcharge claim, guess what? You may have had a great overcharge claim. You're not gonna get you're not gonna get any overcharge at all. On the other hand, if you bring it, 5.5 years later, you will, you will get 6 months of the overcharge, but you would have you would have not gotten a recovery for the previous 5 years. Um,
Oh, and
I
that's only if you moved out?
if especially if you moved out, because obviously if you move in, it's a recurring, it's a recurring wrong, right? You'll be able to keep collecting up to 6 years going back, but you won't be able to collect prior to that. So if you were in an apartment for 12 years, you would have foregone the first 6 years, but
Right.
then, you would collect for the last 6 years. You know what I mean? All right.
Right.
And then, there's this concept that people tend to conflate. There's also this concept of look back to determine what the legal rent should be. But those two things are separate. A statute of limitations to recover overcharges and a look back to determine what the rent should be. Okay? So keep those two things separately. There is a hard line separating what's recoverable on the basis of statute of limitation and what is not. Now, obviously, if you continue to live in the apartment and the rent continues to be illegal, you will be able to recover, 6 years for every 6 year chunk of period. But if you don't bring your overcharge timely, you do tend to lose what you would be entitled to recover by waiting to bring it. Okay, so the current prior to 2019, the recovery period was 4 years, as well as the look back. So that there was congruity between overcharges recoverable and the look back. They both were 4 years. Since the HSCPA, and there's been some variation, but I think we are now at the point where we can say it's 6 years. There was a period of time when there was some confusion as to, because of a Court of Appeals case called Regina versus DHCR, there was some confusion as to whether you could go back retroactively more than 4 years. But given that it has now been close to 6 years since the HSCPA was passed, it's 6 years. So there's a 6 year recoverable period, and there is, and the look back period is not as clear cut as it used to be. I think that's probably the best way
Right.
to say it.
And there's a question in the chat. So does that time period start at the end of a lease or the beginning of a lease? For example, if a lease starts August 1st, 2017, ending on July 31st, 2018, is the 6 years after August 2017 or after July 2018?
Neither. The
Okay, good.
6 year is the date you file your complaint, or the date you file your case in the Supreme Court, or the date you assert your defense. So you file your complaint June 2025. Your 6 years is, I don't know, June 19, 20. I don't know what 6 years minus
2019.
2019.
Oh, right around when HSTPA passed.
So that's why I'm like, yeah, no, but the HSCPA had said, well, you can go back 4 years since the HSCPA. So it's 2015. The HSCPA said, and the law also said, June 2015. So that's why I'm like, well, it was 6 years or the
the later of June 2015. So now it's just 6 years because 6 years is 2021 on 2019. So 6 years is 2019. So it's 6 years. So forget about June 2015. It's 6 years. All right, but okay, so in terms of look back, it used to be, fast, woo, 4 years, and then there was, you know, whether it was 6 years or not. But now it's the most reliable registration. So you can now look back as far back as possible to the last date that the DHCR registration looks legit.
Looks legit according to whom?
Well, that's why we get the big bucks. Yeah. So, yeah. So, I mean, there are some red flags, right? And we talk about that, right? In our outline, we talk about, the rents do not the rents are like even, right? They're like, the rent is $2,000 even. Well, rent stabilization shouldn't be $2,000 even. It should be $1,989.17, but because it's supposed to be increased on the basis of percentages, 2%, 1%, 2.5%. So it shouldn't be even. Registrations that have like a big jump. The rent was 569 something, and then the following year it's $3,000. Well, and then there's no explanation. So obviously you wouldn't rely on the 3,000. You would say, okay, my starting point is the 569.17. Especially if the 569.17 had a history. The previous rent was 509, and the previous to that was 501. So
And there's a question on this whole issue of the legitimacy or not. If the landlord committed fraud as part of an overcharge, is the new rent amount taken from the rent history for that unit or the rent history for the next comparable unit?
see, that was a smart question.
We've got amazing attendees here today.
That was a smart question. Now, I guess I could also be, a smart guy and say, and who has made the determination that the landlord has committed fraud? Is that a determination by DHCR? Is that a determination by fraud? Or is that an argument that the tenant is putting forth? And what is fraud? Is fraud on the basis of what's defined by the Rent Stabilization Code? Or is it, fraud and case, common law? And is it a fraud to deregulate the apartment, or is it a fraud simply to overcharge? So it used to be, by the way, that the courts, including the Court of Appeals, in determining rent overcharges, would limit fraud to be only fraud to deregulate the apartment, fraud to take the apartment out of deregulation. So a simple, mistake in rent increase, instead of taking a 2% increase, they added an extra zero and put a 20% increase. The Court of Appeals, like, that's not fraud because, we can determine what the rent is. That's a simple overcharge claim. That's what they would say. That does not bring a simple overcharge claim does not bring it within the category of fraud that would trigger uh, the rent history being so completely unreliable as to use the default formula. So So that's my answer to you, Sarah.
So, yeah, and I've had tenant association members tell me things like, "Oh, in our building, we've all compared our rent histories, and for, five of them, they have the same fictitious person that's been added to collect vacancy bonuses, but the old timers in the building, they know that nobody with that name ever lived here, especially not in five different apartments. So, yeah, I mean, sometimes, I mean, again, it's just one more thing where talking to your neighbors, sharing rent histories, you're maybe more likely to try to turn up some evidence, and then maybe you talk to a lawyer to see, does this evidence amount to fraud in your expert opinion,
Yeah.
et cetera. And I think the maybe could you clarify what you mean by the default formula? Because some people may have heard that, but it's yeah, if you could share what that means, the default formula.
Yeah. So, by the way, the only reason why this is so hard is because it hasn't yet been settled. Every time a court issues a decision on this issue, it comes up with a different rule. So we have like, 50 court decision with 50 different rules, and we were trying to figure it out. So where do I start? Um, right, okay. Right after right after the Stye Town case, which was a J51 case. Um, um, Roberts versus Tish Spire or Spire Tish. I mean, that was the name of the case. So the Court of Appeals found that the the Stuytown people overcharged tenants for years because they were deregulating apartments, even though they were receiving J51 benefits, and they should not have. So that was kind of a major decision. And then for years afterwards, um, the issue then became, how do you calculate the legal rent? How do you calculate the legal rent? And there were a number of formulas that came from there. One was bridging the gap. The court in Taylor, I remember this, Taylor said, well, one way to determine what the rent is to go back to the last reliable rent and then bridge the gaps. We know that the landlord at one time um, unlawfully deregulated the apartment and charged tenants market rent, whatever they could. But why don't you go back to right before they deregulated it and then see, who came in, what the landlord would have been entitled to get, the vacancy and the RGB increases, and then give them whatever they would have been entitled to get, and then you would derive what the proper rent should be for that tenant. So that's bridging the gap. Okay, bridging the gap. Later on, I think in Regina, the court said, no, you're not allowed to go back and bridge the gap. What you are allowed to do is see whether or not the base date rent was lawful. And if it was not lawful, if it was a product of fraud, and you could go back beyond the base date to do that, but once you make the determination that the base date rent was unlawful, then that's that. Then that's the end of your analysis, and you go to what the regulations say you calculate the rent by, and that's the default formula. And the default formula is you have to calculate the rent on the basis of the lease of three possible scheme. One being you compare comparable rent stabilized apartment, and and you give them, the rent stabilized, the lowest rent stabilized rent in the comparable apartment. But obviously
In
that
the same building,
in
right?
the same building, in the same building. But I mean, that doesn't work more often time because in those buildings, like the Roberts case in Stuytown, nobody was rent stabilized. They had deregulated most of these apartments. So you didn't have any rent, comparable rent stabilized. The other possibility is if you have, and then there's also one where you the the rent minus, a vacancy, 20% or whatever. And the last one is using the zip code analysis um, to find what the average rent stabilized rent for an apartment of the same size in that zip code, which
That's
of course only
massive.
DHCR could give you. So that's the default formula. Did I answer your question?
Yeah, yeah. I've never had that explained to me, so I appreciate it. Yeah.
Uh, all right. Should we do something a little bit more fun? Maybe we should jump to our document and look at the look at the rent registration
Sure.
document.
Okay, so I'm going to do my best to try to scroll to the correct page. Let me know when I hit it, okay?
Okay. And then maybe Vanessa can explain to people what they should be looking at when they look at rent registration.
Oh, wait, is it not? Um, this, I'm going,
That's the
those are
guideline.
the guideline orders, the
That's the
deregulation
deregulation
thresholds.
threshold.
Okay, it might not be in the combined PDF. I'm just going to stop screen sharing for just a moment while I try to
Okay.
find it in the
I,
email.
I think you may have more, but all right. Well, why don't we, um, since we have a little minute while Sarah is looking for the actual DHCR registration history, and then I'm gonna email it to um, Vanessa so she could.
Oh, rent registration, sample rent registration history. It's that, right?
Yes.
Yeah. Okay.
Oh, you have it?
Yes. Let me just make sure I. All right. Okay.
Well,
Uh, so I'm
I'll,
about to share the screen now.
oh, okay.
Okay. We've got it, right?
Yeah. All right. First page. So, um, you want to just scroll it down. Let's look at from 1984.
All right.
'Cause
Oh, and something I love sharing people is this area. DHCR does not attest to the truthfulness of the owner's statements or the legality of the rents reported in this document. Furthermore, this document does not necessarily reflect modifications to the lawful rent, blah, blah, blah. So,
keep that in mind. All right, so this is the first page. And it starts with 1984, and you see the first rent, right? $552.11. And that's what a rent stabilized, that's a nice rent stabilized rent. Why? Because it's it's not a whole number. I'm sorry. I'm looking at okay, so 1984, 379.47. 379.47. Same principle. It's not a whole number, and it has sense, and it's so that should be what a rent stabilized apartment look like. So Vanessa, did you want to take over? Or did you want me to keep going?
Sure. You just want me to talk about what to look for in
Yeah,
the,
yeah.
okay. I'm sure you'll jump in if I miss anything. So basically what you're looking for is really big unexplained jumps in the rent. If you want to just scroll through, Sarah, this is all, those look pretty standard to me. They don't look too huge. There's a way to calculate, make sure that all of the rent guidelines board increases are being properly applied. You could sit down and really do the math on that. And if we were, retained to a case, I would do that. That's the document Serge was saying was our Bible. It's the every rent increase order from 1970 to present, which shows what increases is going to be lawful. This one looks the 1995 to 1996. There's at least an explanation given. So if you're over on the right for the reasons difference change column, vacancy lease, that means that they took that potentially 20% vacancy increase because a new tenant came in. It says improvement, so they're also claiming some kind of improvement in the apartment, potentially an IAI, that allowed them to take the higher increase. It's a little odd that the first column there is legal regulated rent. That's the lawful rent that they're allowed to charge pursuant to those rent guidelines board increases, pursuant to the vacancy increases prior to 2019, and improvements. The actual rent paid, usually in that column, is where if the tenant's getting some kind of housing subsidy or something like that, the actual rent paid might be different than what the legal regulated rent is. It's a little odd that it's higher than the legal regulated rent. That's not a good sign. I don't know if that could also be evidence of like the landlord just made an accounting error. It's not a huge discrepancy between 621 and 636, but usually the actual rent paid is going to be lower than the legal regulated rent.
Yeah, it's a big jump.
Yeah. Yeah. Sorry.
Yeah.
Sorry.
Yeah, there we go. 687 to 728. Yeah, that would be, especially since the tenant there remains the same, right? So there's no vacancy increase that a landlord can take if the tenant remains in occupancy. So you definitely want to go double check, what was the allowable increase for the rent guidelines board that year? I don't know it off the top of my head. I'd have to go check the chart. Maybe it's, and again, I'm not good at math enough to do this on the fly, but if it's 5%, then you should sit down and calculate, what's a 5% increase on 687, 49, and add the two together at, 687 plus that 5% increase. And if you're getting a number that's lesser than the 728, that might be evidence of some kind of overcharge. What I will say is that sometimes, just because the landlord didn't write improvement in that column over on the right, reasons for the increase, doesn't mean that he didn't do some kind of improvement to allow that increase to be lawful. And it doesn't preclude him from, coming forward later and saying that was the reason for the increase. So if you do file a complaint based on this, jump that we identified between 2001 and 2002, for instance, then he could come forward with a claim that he did some IAIs to sort of justify any increase beyond the rent guidelines board allowable increase for the year. I'm gonna keep scrolling. 728, 783, 826. That's another bigger
Bunch of
jump.
years where the rent just stayed the same.
Yes. And this is very odd, right? Now we have it goes from, there is a tenant, they don't have to register a rent when it's vacant. Serge, I think I'm right about that. But it is odd that now they're registering it as exempt, right? It's vacant for a number of years and then allegedly exempt starting in 2010. Not a primary residency, not for profit. Those, I'm gonna let Serge talk about what those entries could possibly mean, because I know that there's a couple programs that potentially this could be lawful, but I'm not familiar with them.
Yeah, so this is actually a live case that we have going on now, and I thought I would give it as a sample because it raises a number of issues. But before I go on, Sarah, could you just go down just a bit? I'm going to go back to the not prime resident, not for profit. But keep going down because something really funny happened in 2019. Okay, so boom, look at this. 2019, the apartment is registered as RS vacant, but this date is funny, right, Sarah? June 19, 2019. Why?
5 days after HSTPA passes.
It's like now, if you are looking at this and you don't know when the HSTPA passed, and then they register it, and I think the HSTPA became vacant. I mean, became effective June 20. I mean, it passed, but then it became effective, and you could check it out. Let's check it out. Let's just Google it. That's the beauty of having information on the tip of your finger.
I've certainly seen a couple rent histories where all of a sudden on June 14th of 2019, all of a sudden there's a new registration.
Oh no, actually it's June 14. Yeah. Um, so it says June 14, but th that that date kind of made me when I saw it, I'm like, this is a landlord who's very aware of there was a law passed in 2019 that impacted whether the apartments stabilize or not, and the landlord is trying to play games. So then you notice after 2020, 2021, the apartment's just not registered at all. That before it was exempt, 2019, they register it, and then boom, not registered at all. Now, in terms of not for profit, it so happened that that building was owned by a school, by a college. But the law, though, is very interesting, right? The law is not just, if it's owned by a college, it's automatically exempt. That's not what the law says. So a lot of times, like Columbia, NYU, they'll buy occupied buildings. So, but obviously, just because they own it, and then we have a lot of clients uptown where Columbia is the landlord, but they were there before. They have no relationship whatsoever with Columbia. They are subject to rent stabilization, notwithstanding the fact that Columbia, is Columbia. Columbia is a not-for-profit organization or a college or a university. So, in fact, if you read the law, it specifically says that the exemption does not apply to tenants who were in occupancy prior to the ownership, the not-for-profit ownership. So that's one exemption. The other exemption from the exemption is that it has to be used for exclusively for the not-for-profit purpose. So if it has to be used for exclusively, and I guarantee you, most not-for-profit organization will have a problem proving that this exclusive requirement. And the person in occupancy has to be related, has to be living there in the apartment for it to be exempt from rent stabilization as an incident of their relationship to the not-for-profit. So simply because it says not-for-profit, and simply because it's and the person, you check who owns it, and it's like, oh, it's Columbia or it's NYU. That does not make it exempt from rent stabilization. You gotta, exemptions are to be applied very strictly and very limitedly. And in this instance, I think we have a very good claim that the apartment was not in fact exempt. Okay. So, I mean, this is, these kind of things, I think Sarah mentioned it. It's like they are fact specific. They are apartment by apartment specific. Simply because I gave this as an example, not because it has any relevance or any importance. It's just, interesting how the rents change, and we had this, vacancy and no registration found. But they're going to be, apartment to apartment specific, and they're going to have their own little quirk and their own little, game. So you're going to have to look at them carefully, look at the law, the applicable regulation, the applicable law, and see if there's anything that you can make out of it.
Yeah, and maybe for anybody here who just hasn't looked at many rent histories before, when you see this line, reg not found for subject premises, it doesn't it just means that a registration wasn't filed that year, right? You might see something above it that says exempt from, and then it usually should say some kind of reason of why it's exempt from rent stabilization, according to them. A very common one you might see is exempt hyphen high rent vacancy or something like that. Here on this one, we see a registration in 2019, and then it just says registration not found. And so every landlord is different. Some of them are better about paperwork than others. Sometimes a landlord just doesn't register. And actually, after 2019, a lot of landlords kind of, it's almost like they were going on strike or something. Like, I'm not going to register just because they were mad. And then they could file registrations afterwards to kind of catch up with their paperwork. But yeah, I don't know if there was more you wanted to share about, the rest of this rent history or just what people should make of it. Because I see somebody had asked a question, is it common for a rent history to just go dark for a period?
Yeah. Well, this one this one is interesting too, because the the owner was a university, and they sold it to, a very prominent landlord. Um, and of course, they were saying, oh no, the apartment's not regulated because when your client moved in, it was above the threshold. The rent had already reached the threshold. And in support of that, they provided documents. But, you know, and maybe I should have given you the documents as well, because the documents raise a number of issues, right? The whole plethora of issues, the related entities, the the fact that, they claim the client moved in prior, of course, right, in May of 2019, while all the check and all the invoices post dated, um, they were mostly actually in August of 2019. So yeah, there's no magic trick. You just have to look, and you have to go through each of the document, because a lot of time the truth is hidden somewhere there. Um, they were trying to say, in this case, the landlord was trying to get around the HSCPA. He was trying to say the apartment was vacancy decontrol. because the client moved in prior to, the HSCPA and the rent was above the threshold, but clearly that was not the case. So
Yeah.
you just got to study, them carefully, and you can't make assumption. You have to go back and look at the law, see what it says. All right, so this is the fun time where if there's any other question that Vanessa hasn't answered, Vanessa is very efficient, as you can see.
Yeah, it's amazing. I almost wonder if we could just, if I ought to just, for the benefit of the video, just read off the questions with the answers that Vanessa has given because they're great. One thing that just as a housing court answers employee, I have noticed is that sometimes tenants come to us in the court and they, they're in a non-payment case in housing court and they say, well, I've got this DHCR complaint that I made a year ago. And we're, now at the point where it's like going to trial and they just feel very confused about what they should do. Um, you know, they wonder, is there some way to force DHCR to go faster so that I can get the decision out of them before my housing court case wraps up or before I go to trial? Or is there a way to switch from DHCR to housing court? Or I guess maybe I know that we've talked about how path dependent and situation specific all of this is, but um, I don't know if you maybe wanted to share your thoughts about this whole venue issue, because I saw that somebody had asked a question sort of related in the chat. When you kind of are standing with 1 feet on either side of the fence.
Yeah. Again, I mean, this is tough, right? Because there are so many variables, so many considerations. Um, we had Vanessa and I, actually it's Vanessa's case mostly, had a case where the client had filed a DHCR complaint right before the housing court case was commenced. And we thought we had a decent judge in housing court. So we wrote to DHCR asking DHCR to terminate the case so that we could litigate the rent regulated status in housing court. But that was a situation where I don't think we were concerned about overcharges, and we certainly were not going to lose any recoverable, overcharge amount at the time because he had filed the rent overcharge complaint like a few days before, so we weren't going to lose much. So it's hard to answer your question because I don't really know how long that person filed their overcharge claim and whether withdrawing it could adversely impact their claim in terms of both the look back period and how much money they can recover. Because remember what we were talking about, every time beyond the statute of limitation you lose, that's money you can't get back. So yeah, that's just a hard, it depends who's your judge. It depends what the issues are. It depends when you filed it. Because I'll tell you, I have a case in Supreme Court where whether I win or not, and I kid you not, depends on whether the base date rent is May 1, such and such, or June 1. It is, it's, sometime, that 1 month can make a difference. So it's hard. I mean, generally, I would prefer to litigate things in housing court, but that's a general proposition. You can't, use these general consideration and general rules for specific cases. You just have to know what the facts are.
Yeah. Well, and also, DHCR has a fact sheet that talks about how a judge in a court can ask for something to be expedited processing, but it doesn't mean that the judge that you have in housing court is actually going to do that.
Well, there's two things, right? Number one is it doesn't mean that the judge is going to actually do it. And number two is it doesn't mean that even if the judge does it, the ACO is going to do anything about it. And then it doesn't mean that if DSCR doesn't do anything about it, if the judge is gonna, have the backbone. I'm from Brooklyn. I have better choice of word to, to follow up, right? How many judges if nothing happened, they're gonna like get on the phone and say, let me speak with your supervisor or something. Most of them, I tried. So I haven't had somebody in this say it the Brooklyn way. I haven't had a case where the court, I mean, I don't know, maybe Vanessa's practiced more in Brooklyn more recently than I have, but I haven't had one where a judge has written to DHCR and DHCR has issued a decision like forthright. I don't see it. Well, maybe I'm just cynical.
Yeah, definitely not, unfortunately. We had a question in the chat about Frankensteining, and I'm just
Oh,
not as up on it, so I thought I'd be a good one for you. The question was that his apartment was a one bedroom for 1,100. When rented to us in 2023, it was a two bedroom for 2,300. The rent history confirmed it was still regulated, but did not have our rent amount, so we believe the landlord did not legally deregulate it. But because there was a loophole, we don't know if it was fully illegal. He asks about the impact of the 2024-2025 law that Hochul signed to stop the Frankensteining loophole, and whether there are any updates about how this will play out with rent overcharge apartments and will it apply retroactively?
and you, Vanessa, answered the question thoroughly, right? You give them a 20-page brief.
I answered the question by saying I'm going to ask Serge.
Um, so I guess I would want to know when that person moved in and when they filed their overcharge to kind of determine what rule applies, whether it's the post 2023 December 2023 rule, or if it's the pre HSCPA, or if it's the post HSCPA but pre December 23 rule, because they all very different. But generally, I mean, the first thing is whether or not by combining the two apartments, they created truly, I mean, pre-HSCPA, I would say that would be the issue. Whether by combining the apartments, they created truly one new and newly created apartment, where, the perimeter walls have been expanded and where the newly constructed apartment is truly newly created. Because I had a case recently, but this was pre-HSCPA, where, I mean, the kitchen cabinets were removed, and they created a doorway between the two apartments. But other than that, nothing else was changed. And I won. And it was like, no, you didn't create a new apartment. You just combined two apartments, and therefore the rent should remain rent stabilized. And the rent should be, the rent, regulated rent for the previous two apartments. Post HSTBA, I mean, even if the apartments are now, duly created, they still remain rent stabilized. And whereas before, if it was a first rent, if the first rent was above the threshold, it could be deregulated. Now it cannot be. Now, even if it is a first rent, the first rent is simply a combination of the two previous rent regulated rent. But I would want to know, when exactly it happened to determine which regs apply. And unfortunately, there are three separate regs, and they're so close in time to each other too. They're like months apart.
I think he's saying he moved in November 2022, if that.
So then it's the HSCPA. So they can charge a first rent, and what the first rent is, the first rent is definitely not post December 2023 rent, which is combine the two rent, and that's it. So between 2019 and 2023, the owner could charge a first rent, and but the first rent has to be rent stabilized. But what that first rent is and whether it's challengeable, I don't know. I would have to look into it a little bit more. And if it's prior to HSCPA, then the issue is whether it's truly a newly created space and not simply a combination of two space.
Also, just gonna put this out there. Next week, uh, Friday, 2 p.m. on Zoom, we're gonna have another workshop. It'll be the last one in our advocate and organizer series for this spring, and it'll be on deregulation risks for rent stabilized apartments, the ones that remain after 2019. So if Frankensteining is a burning hot topic for you, you might want to tune in next week for HCA's next presentation. Yeah, it'll address things like substantial rehabilitation, um, demolition loopholes, co-op and condo conversion. Yeah, and actually that's another question and I see we're getting very close to time. Um, uh, if an apartment was deregulated through substantial rehabilitation, would that show up on a rent history?
It should. It should say deregulated, substantial rehabilitation.
Oh, would actually they would put theoretically they would put the code substantial rehabilitation, but would there be any way to challenge it after that's already happened?
If it's truly a substantial rehabilitation with new certificate of occupancy issued, and yeah, I guess you could challenge anything, whether or not you whether or not
And whether
you
you succeed or not, I guess, is another question.
yeah. You could, I mean, I've had a few cases where there used to be a time, and this is what I meant too when in the beginning I said DHCR is truly opaque and non-transparent. There used to be a time when if you didn't want, if you weren't challenging overcharge, you just like, look, I just want to know my status. You could write DHCR, you could do what's called an administrative determination, an AD request, and you could say, I'm writing to determine the status of my apartment. The landlord says my apartment's deregulated on the basis of substantial rehabilitation, but I looked at the DOB website. I don't see a new C of O. I've had neighbors here since the beginning of time. They say that there was no, so you could do that. But lately when I've done that, they've returned the form to me and they say, file a rent overcharge.
Hmm.
So even, which, I mean, ultimately the rent overcharge will reach the same issue, right? We'll first reach whether the apartment's rent stabilized, because it can't be an overcharge if there's no it's not covered. But yeah, they don't have. So so Sarah, you asked whether you could challenge it. And I guess my my answer is yeah. There used to be a time when you could challenge status at DSCR by filing an administrative determination, but lately they've been rejecting those and saying file rent overcharge.
Hmm. Right. Um,
Oh, by the way, I mean you know that there are rules about what constitutes substantial rehabilitation and how much of the structure has to have been done over, what the roof, stairs, and mechanics. So there are rules for what constitutes substantial rehabilitation.
right, right. And people should definitely tune in to get more details on that. Somebody had also asked in the chat if because it's been so valuable to have questions answered here and there, by Vanessa, if it was possible to have some of the chat, maybe something that I would propose, and I'll see if it's okay with you. Maybe I could create a document that could be shared afterwards that would have, you know, questions that were asked and answers from the chat, and we would just take out people's names. I don't know if that would be okay with our presenters because, all of these answers have just been so valuable.
Fine with me.
Yeah,
I do think I probably missed a couple. I'm sorry, I'm going through now trying to look at them. So I'll try to get to everybody, but if we run out of time, I don't know if Serge has already given, I'm sure, like contact information if people are interested in discussing their cases more and want to set up consults with the firm or something. That's an option as well.
Yeah, so maybe if you let's see, would it be best to give email addresses, or should people go to the Himmelstein, Gribben and Joseph website? What would be the best way for people to reach out to the
oh,
firm?
email is the best way because we respond to email 24/7.
24/7, good for you.
I don't make that promise. Normal business hours.
Sure. So, yeah, do
I'll
you
put
want
mine in
to
the
give
chat.
your email addresses?
I'll put mine and Serge's in the chat, no problem.
Okay. And great. Okay. And that's S Joseph, that's for Serge, at hgjlaw.com. And
No,
the
it's
oh,
HGJ. Yep,
mhm.
yep. HGJ.
Yeah, hgjlaw at .com. Sorry. And then Vanessa's is V Vecchiarello, Vecchiarello at hgjlaw.com. Yeah, so I want to thank you both so much for giving this presentation today on this very thorny but very interesting topic. It's just a constant source of consternation for tenants. And so getting these deep explanations from you, understanding that we can't have a crystal ball for everybody's situation, but yeah, this presentation has been very helpful, and thank you so much for being here and sharing this information with us.
Thank you for having us. And we look forward to doing this again. Next time we'll switch role. I'll type up answers and Vanessa will share war stories with you all.
Tremendous. All right. Oh.
All
Okay,
right.
I'll make
Take
sure
care.
that I save everything in the chat so that I can put it into a readable document. later on. Figure that out. Copy. And yeah, I will figure out how to either mail this to everybody or turn it into a document that can just go onto HCA's website so anybody can access the question and answers, obviously with people's identifying information taken away. Okay, so thanks everybody for being here.
No problem. And we'll talk soon. Bye-bye
All
now.
right,
Thanks.
bye-bye.